Good afternoon, ladies and gentlemen. My name is Kartini Mageswaran, and I am a case counsel for the Asian International Arbitration Center. It is my pleasure to welcome all of you here this afternoon to the AIAC YPG Conference in conjunction with the 6th AIEC Pre-Moot for the William C. Viss International Commercial Arbitration Moot. Current state of international trade and arbitration. Has the dust settled? To get started off with our conference today, I would first like to call upon the AIAC YPG co-chair, Tharshini Sivadass, to give her welcome remarks.
Thank you, Kartini. Dear distinguished guests, it gives me great satisfaction to have each and every one of you join us here today. We are very pleased to be able to welcome those of you that have been with the AIAC Young Practitioners Group for a long time now, as well as those of you who are new to the group. To start, I would first like to thank our speakers and moderators who have expended both time and energy to prepare for today's event. Your passion for the young legal fraternity is appreciated. I would also like to thank the attending delegates. Today you will learn from different perspectives and stand to gain much from the collective insights and experiences of our panelists, who have all cultivated inspirational individual career trajectories. As you are only too aware about, we are all in the midst of a difficult time like no other. First the pandemic, and now the war, has sent shockwaves through global alliances and also the global economy. I imagine that for young professionals, very much like myself, these ongoing concerns are an added cause for worry and anxiety. However, I believe that it is within frameworks, just like our YPG community, that we can build bridges and strengthen networks across all differences and diversities, and come to work together from various parts of the world on issues, sharing and exchanging our ideas. It is my pleasure to walk you through our planned sessions for the conference today. In our first session, the complex issue of pitfalls and tactics relating to contractual claims that arise in commercial arbitrations will be canvassed by our panelists. In session 2, the panel will delve into the issue of party autonomy, commenting on the appointment of neutrals in multi-party arbitrations. Lastly, we will end with an exciting debate on how to best protect the integrity of arbitral proceedings when presented with procedural challenges. Please do vote your winner. I conclude my welcome by encouraging the delegates to participate today by asking questions and keeping the discussions going. And last but not least, joining us for all upcoming YPG initiatives. I wish everyone a fun and fruitful conference. Thank you.
Thank you, Tharshini. Moving right along, it is now my pleasure to have our director of the AIAC, Tan Sri Datuk Suriyadi bin Halim Omar, give the opening remarks for the conference.
Assalamualaikum warahmatullahi wabarakatuh. Dear students, practitioners, and our distinguished guests, I wish you all a good evening and thank you for being here with us today. It gives me great pleasure to welcome each and every one of you to the YPG Conference 2022 themed Current State of International Trade and Arbitration Has the Dust Settled, which is hosted in conjunction with the 6th AIAC Pre-Moot for the William C. Viss International Commercial Arbitration Moot. The AIAC's Young Practitioners Group, or as it is more fondly known as the YPG, was established in March 2017 with the goal of youth empowerment. Under the YPG, junior level practitioners and students with a keen interest in the field of ADR are brought together to increase their awareness of challenges and developments within the ADR industry, as well as explore various opportunities to participate in international events, much like this one. Over the past year, I am proud to share that the YPG has had several notable achievements And I would like to highlight the launch of the YPG podcast series titled Inside Stories, which aims to provide us with a holistic understanding of the ADR landscape from the perspective of seasoned practitioners. Another key highlight is the YPG's collaboration with young arbitral women to host a virtual workshop titled Breaking Down Barriers, an interactive workshop on cross-cultural communication of international arbitration. We will also be launching the AIAC YPG Essay Competition 2022 later this year with a topic focused on international investment arbitration. I therefore encourage all of you to participate in this competition to showcase and refine your research, analytically and drafting skills. Ladies and gentlemen, to start off the AIAC YPG conference today, we have Professor Ulrich Schroeter, who will deliver the keynote address on the interplay of international trade and arbitration, one step forward or one step backward. Professor Ulrich Schroeter is a well-celebrated academic in the field of arbitration and is currently a professor of law at the University of Basel, Switzerland. He has published books, chapters, and articles on international trade law, arbitration, commercial law, and financial markets regulations, and has received awards for both his research and teaching. I am delighted that he has accepted our invitation today, and I believe we all stand to greatly benefit from his views as he delivers his keynote address. You will also hear from impressive and diverse panel of ADR practitioners from across the globe in 3 sessions that we have today. There's certainly a lot to learn today, and the sessions have been organized to be engaging and informative, encompassing discussions on the complexities of contractual claims in commercial arbitration and the thorny issue of balancing party autonomy when appointing the tribunal in multi-party arbitrations. The conference is set to end on a fiery note, with a debate on the best approach that may be adopted in the face of procedural challenges. I take this opportunity to thank Professor Ulrich Schroeter and all speakers for their time and efforts in contributing to the success of this conference. At the end of today's conference, we will be gearing up in excitement for the 6th AIAC Pre-Moot for the William C. Weiss International Commercial Arbitration Moot, and I am especially honored that this year's moot problem features the AIAC Arbitration Rules 2021. I hope you enjoy the competition, and I would like to sincerely thank all sponsors and supporting organizations for their friendship and partnership towards the 6th AIAC Pre-Moot. I also urge all participants to take full advantage of this pre-moot as you prepare yourselves for the upcoming Weiss Moot and the Weiss East. The stage is set, and it is now up to you to shine. Thank you and stay safe.
Thank you, Tan Sri. Next, we will have the opening remarks by Ms. Shariha Razman from Mohanadas Partnership as the platinum sponsor for the YPG conference deliver the opening remarks for our conference.
Welcome to the AIAC YPG Conference in conjunction with the 6th AIAC Pre-Moot for the William C. Weiss International Commercial Arbitration, organized by the AIAC. I'm especially pleased that for 2 years running, Mohanadas Partnership is privileged to be its platinum sponsor. My special thanks to Tan Sri Datuk Suriyadi Halim Omar, Director of the AIAC, for giving us this opportunity to be part of this event once again. And also a warm thank you to Dr. Prasad Abraham, Deputy Director of the AIAC, for having us here once again at this historic Bangunan Sulaiman. The AIAC Young Practitioners Group was established 5 years ago in 2017. Since then, the YPG has grown in members from all jurisdictions, including Australia, Cambodia, China, England, Hong Kong, and as far as Mauritius. Many congratulations to the YPG committee under the leadership of the current co-chairs, Ms. Tharshini Sivadass and Mr. Lin Siwei, for organizing this conference, and also for organizing the many events that it holds on an annual basis. It is a fantastic achievement by the AIAC that it has managed to continue the pre-moots and also this conference, notwithstanding the ongoing pandemic and pressing economic challenges, both in Malaysia and beyond. In line with the new norms, the facilities at the AIAC has enabled arbitrations to proceed domestically and internationally, and has made arbitration more accessible to parties in these challenging times. My heartiest congratulations also to all the participants and speakers who have taken on the challenge of participating in this event remotely, despite the technical glitches and the differing time zones. This is indeed the spirit of cooperation and accommodation that are necessary for the exchange of ideas and intellectual growth in this new normal. I think that the participants are in for an interesting and exciting treat with this year's topic, Current State of International Trade and Arbitration. Has this thus settled? The topic for discussion will raise many interesting issues that are relevant to the current situation, including issues thrown up by the unforeseen global pandemic. Lastly, our thanks to all the staff and management team at the AIAC for the continued and unwavering efforts in making this event possible. On behalf of Muhannadas Partnership, I wish you all a wonderful conference. Thank you.
Thank you, Ms. Shariha. Ladies and gentlemen, please now join me in welcoming the keynote speaker to today's YPG conference, Professor Doctor of Laws, Ulrich G. Schroeter. Professor Dr. Schroeter is a full professor of private and comparative law at the University of Basel. He teaches and publishes on topics of commercial law, contract law, international trade law, arbitration, treaty law, and financial markets regulation. Much of his current writing deals with the 1980 Vienna Sales Convention. His works have been cited by courts in Australia, Austria, Germany, the Netherlands, Switzerland, and the United States of America, as well as by advocates general at the European Court of Justice. Prior to taking up his position in Basel in 2017, Professor Dr. Schroeter was a professor of law at the University of Mannheim, where he held the chair for private law, international corporate and financial markets law, and European business law. He was educated at the Albert Ludwigs University Freiburg and the University of Lausanne. Professor Dr. Schroeter received a doctor juris from the Freie University Berlin before completing his postdoctoral qualification at the Albert Ludwigs University Freiburg. He was a visiting fellow and is now a life member of Clare Hall, University of Cambridge. Ladies and gentlemen, Professor Dr. Schroeter for the keynote address, The Interplay of International Trade and Arbitration, One Step Forward or One Step Backward.
Thank you very much for the very kind introduction, and it is a great pleasure to join you today from Switzerland, where the day is just starting outside. I was very pleased when I received the invitation to speak at today's conference. I wish we would all be meeting in person in Malaysia, but for obvious reasons, that is not possible. So we have to make do, as real arbitration live today also has to make do with a virtual setup and make the best of it. The topic of the conference today, as you all know, has the words "has the dust settled" in it. And the beginning of the blurb for my keynote starts with the word "as the world moves forward and regains normalcy." As was indicated just a minute ago in the welcome, since the time I accepted the keynote speech a while ago and today where I'm holding it, another unforeseen disruption has emerged in Ukraine. And this, while not being the topic of my speech today, I believe gives an indication that the world of arbitration, as the rest of the world, has to adjust to changing unforeseen developments, not only during COVID, but also in other circumstances, and is likely to continue to do so if it wishes so or not. So I will try to address in my keynote how this adaptation, how the innovation, the development of arbitration should be conducted, is likely to be conducted in the future, in particular in the aftermath of COVID, whenever that aftermath will actually start. Let me commence, in order to do so, with some basics that I'm sure everybody here in the virtual room is well aware of, but that I believe deserve to be called into attention once more when trying to look forward. The basics are essentially that arbitration is not the default solution for the dispute settlement in international trade per se. Arbitration is a creature of choice by the commercial parties. That, of course, is something we all know. The basis for each arbitration is the arbitration agreement between the parties, and in the ongoing Pre-Moot, that is a topic that in quite some detail the teams will be addressing. However, what we tend to have lost sight of is when in 1958 the New York Convention was adopted, there was another feature in the New York Convention that today we take for granted, and maybe we shouldn't. That was the states' commitment, the states that agreed on the New York Convention and subsequently ratify it, to take a step back and to recognize arbitration as a means of dispute settlement. In doing so, recognizing that the freedom of the parties and of the arbitration community was, in many cases, or in the cases the parties so chose, the best way of settling international commercial disputes. The New York Convention says that in Article 2, when it says each contracting state shall recognize an agreement in writing under which the parties commit to arbitration. And in Article 3 says each contracting state shall recognize arbitral awards as binding. Today, when we talk about the New York Convention in arbitral practice and in arbitral academia, we mostly focus on more specific items, like the list of reasons why an arbitral award may exceptionally not be enforced under Article 5 of the New York Convention, and the question how these rules, these particular items listed in Article 5, may indirectly influence the way that an arbitral tribunal has to conduct the arbitration, when doing so with the aim of creating an enforceable arbitral award. But underlying the New York Convention is also the general commitment by the states to leave freedom to the arbitral process within certain limits, of course. And those primarily are those listed in Article 5 of the New York Convention, the public policy exceptions, and other minimum rules of standard of conduct that the arbitration has to adhere to in order to result in an enforceable award. The answer trial model law on arbitration mirrors those rules almost identically when outlining under which conditions an arbitral award can be set aside at the seat of the arbitration if one of the parties applies for it. The result of this setup, as we all know, is essentially arbitration law as a core of established principles surrounded with a lot of flexibility, freedom for the parties, for the arbitrators, for the arbitral institutions to design procedures that are particularly fit for the purpose they want to use arbitration for. But we should never forget the central underlying conditions is always the agreement of the parties to go to arbitration. The question that has been posed to me in the keynote today, do we take one step forward post-COVID, or should we take one step backward and look at the scene, outlining whether arbitration is still appropriate in today's changing world, or whether maybe an alternative means of dispute settlement will take its place? I believe that we could phrase that question differently and not think of it as a step forward or a step backward, but rather as a dance between the arbitration parties, the commercial parties who choose to arbitrate, and the arbitration community that offers arbitration services. And I believe in that picture, it is this dance, one step forward, one step backward, and then turning around. If we were in Vienna, it would be a waltz. In other parts of the world, it may be a different type of dance. That this arbitration dance, if you allow me, will be the way we will forward and improve arbitration over the upcoming years. That requires a constant interaction between arbitration service providers on the one hand and the commercial parties, the users of arbitration who choose arbitration as their means of dispute settlement. And it is this interaction that will eventually determine how arbitration will develop, what changes it will undergo, may have to undergo, and how successfully it will compete with other modes of dispute settlement that are out there and that are equally developing over time. The arbitral dance that I'm suggesting to you as a picture faces various challenges, and I will be addressing 5 of those. The first one is that commercial parties typically do not want to dance. They are not eagerly entering into an arbitration, but they are, if you will, rather standing on the side of the dance floor and watching what is going on there, preferring not to participate, standing at the bar, having a drink, and watching the dance go by. Designing an arbitration agreement and participating in an arbitration agreement is, for commercial parties, never particularly attractive. They would much prefer their deals, their transactions go through without any dispute settlement becoming necessary. Of course, they know that every once in a while the deal turns sour and they will need arbitration and the assistance of lawyers like us today here in this virtual room, but they're not enthusiastic participants at all. The question is, does that reluctance of parties mean that arbitration will entirely go out of fashion? No more dancing for anybody involved. Put differently, will arbitration be replaced by different means of dispute settlement in the aftermath of COVID-19? I believe that that is unlikely. And the reason is simple. I believe that the underlying needs that commercial parties have and that they expect to be fulfilled by the means of dispute settlement that they choose have not fundamentally changed, neither through the COVID pandemic, nor will they fundamentally change through ongoing wars and other developments that may come in the future. The needs would have to fundamentally change to enable another means of dispute settlement to be a viable alternative to arbitration. What would that alternative be at the moment? How would it be fundamentally different? Of course, it can differ very well in details, and those details may be some that arbitration can learn from and can incorporate or can engage with by combining 2 different means of dispute settlement. But are fundamental components of arbitration as arbitration has developed over the past decades and centuries really have gone out of fashion? Are they no longer needed? I do not think that that is true. I do believe that the parties still want an efficient means of dispute settlement, and they also are conscious of the fact that, although not desirable, every once in a while there will be the need to have a dispute settlement means that can be executed and later on, in the form of the award, enforced, although the counterparty is not wishing to participate anymore. Voluntarily, if it voluntarily won't be done, then the sharp end of arbitration will be a necessity and a valuable component for the commercial parties. Put differently, if the commercial parties would want something fundamentally different for arbitration, they would choose it and no longer opt for arbitration. And in such a case, arbitration providers would arguably try to remove the weaknesses of arbitrations that the parties have identified and try to engage them again in choosing arbitration. I therefore believe that arbitration will not go fundamentally out of fashion, but it will have to improve. It will have to undergo innovations, and details will, and arguably deserve to be changed from the way that arbitrations are conducted today. Returning to my dance picture, the question is, how do commercial parties choose their dancing partner, their commercial service providers? The important part is, it is the commercial parties who choose. Arbitration institutions, arbitrators, practitioners can only offer their services, and they have to be convincing enough to the parties to be the ones that they opt for in the arbitration agreement, and later on, after a dispute has arisen, at the counsel that they turn to in order to represent them in the arbitration, the arbitrators that they will appoint. Who will be chosen? Most likely those who dances the most smoothly, who offer the best dancing experience. The difficult part is, again, that the parties who are one part of the dance are not particularly eager in engaging by designing the rules of the dance, by drafting particularly good arbitration agreements or arbitration rules. They're not experts in this area, nor do they care much in commercial practice. Arbitration agreements are the fine print, somewhere on the back of the form or tucked away in some email that may be sent in time or maybe too late, and that is far removed from the commercial core of the deal as a commercial party views it. It is this lack of expertise and lack of interest that makes sure that it is the arbitration service community that has the task of developing innovations and offering those innovations to the parties to accept. Undergoing innovations in arbitration has in a certain way the advantage that changes in arbitration rules or in the simple practice of conducting an ongoing arbitration are often more easily implemented than the change of a court structure, of court rules in a state court, where the legislator has to step in and where it sometimes will be very difficult to reach agreement. We have seen that in the course of the COVID pandemic, when arbitration has generally adapted quite well, not always without hiccups, but generally has been able to continue to provide those services after some more difficult phases in the beginning, while in a number of states, at least, the court procedures underwent much more significant problems and delays. Even if such an innovation and an adaptation has been provided, however, it will always have to stand up to the party's choice and their preferences when choosing a new arbitration venue for the next dispute. An inherent complication with relying on the party's choice as a test of the quality of arbitration services that have been developed lies in the time lag that we have. The parties agree on arbitration when in the moment they conclude their transaction, typically their contract. The time that lapses until arbitration will actually be needed can be long. It typically will take some time. So the choice that affects the dispute settlement that takes place 10 years later has been made at a point in time when innovations may not yet been implemented. This time lag is a disadvantage in arbitration, but it is inherent. Of course, technically, the parties could adjust their arbitration choice after a dispute has arisen in order to opt in developments that have been made since they chose for arbitration. But as we know, that in practice will not always be possible, because once a dispute has arisen, typically the degree of cooperation between the parties has shrunk significantly, and they often will not be willing to engage in a change of the rules they agreed upon in their arbitration clause. Particularly the respondent will often not be particularly eager to engage in changing those. So the time lag is an issue that we have, but it is inherent in arbitration and in the structure that involves the arbitration agreement as a basis for any future dispute settlement. We can partially compensate it through the flexibility that many arbitration rules give the arbitral institutions and the arbitrators in designing the specific dispute settlement that will take place after a problem has arisen. Not everything is specified in arbitration rules with good reason, because that gives a certain leeway to arbitrators to design suitable rules if the parties cannot agree to formally change the rules that they have agreed to earlier. In arbitration and in arbitral dance, if you will, the dance styles have changed over time, and they need to change. Innovation is necessary. The question is, who will implement innovation in arbitration? A variety of actors come to mind. First and foremost, it will be the dispute settlement community itself that comes up with innovations and try to solve and remove certain disadvantages that have emerged in the eyes of the arbitration users, sometimes in the eyes of service providers themselves. And that has been a development that has always gone on for a long time. More recently, we have seen, that emergency arbitrators has been a feature that was developed because the need had emerged for parties to resort to arbitration before a arbitral tribunal had been formally constituted to receive quick relief. And more arbitral institutions have developed and designed means how an emergency arbitrator can step in. These means influence themselves between the different arbitral institutions, but they're not identical. And that's a good thing, because the parties can therefore judge which of the developed innovations works the best and can, by their choice, by voting with their feet, make sure that the arbitration community sees what, in the eyes of the commercial parties, is a particularly successful new arrangement. The arbitration community will also be the one that will continue to develop innovations, and that has done so in the COVID pandemic, where there was no time to wait for legislators to change the lex arbitri. The service providers, institutions mostly, were much faster and much in doing so with good reason. Sometimes, however, we need the lawmakers in order to implement certain innovations. That is in particular the case when it comes to enforceability and enforcement. We have seen an important step in this regard by the Singapore Convention that for the first time has provided a suitable means of making mediation settlements enforceable in courts, and that therefore has given in a certain way teeth to mediation outcomes that was lacking before, and that ideally, that in reality, neither the arbitral institutions nor the parties could really design themselves. So in this regard, lawmakers from around the world have come together and have found in the form of this new convention a solution. That solution will still have to prove itself in practice, but it is to be welcomed that that need has led to a reaction by the lawmakers in this area. Occasionally, we have an interaction between both actors, the arbitration community and the lawmakers, in order to enable changes in arbitration. An example of that arrangement from recent times has been the increasing use of third-party funding. In a number of jurisdictions, third-party funding could be implemented without involvement of any lawmakers. In my jurisdiction, Switzerland, for example, there is nothing in the law that would prevent arbitrations from being funded by a third party. So here, it was more the arbitration institutions and arbitration practitioners who had to find and develop ways of how to involve third-party funders. That is an ongoing process. But in some common law jurisdictions, that was a more complicated matter because traditional common law rules prevented third parties from, in a way, betting on the outcome of judicial proceedings. And in a number of jurisdictions, the lawmakers have stepped in and have opened up a window for third-party funding in arbitration, sometimes in arbitration and court proceedings, in other jurisdictions just for arbitration, and have therefore enabled an improvement and development of arbitration by leaving, in a way, by opening up the space for dances a little wider than it was before. Any innovation that is developed in one of these ways, however, has to be approved by the parties by choosing the respectively changed rules. It all depends on the party's willingness to use, the party's willingness to dance. Occasionally, innovation is driven from outside influences. And the COVID pandemic provides a very good example for such a development. We have seen an increasing move to virtual arbitration hearings, to virtual meetings, to moving from paper-based documents to online documents to electronic documents, although that was already in development but took place earlier. And the question that we are facing today is, what of these changes that have been implemented throughout COVID and that currently are still used, because COVID, as we know, is not over yet, will remain after the pandemic has hopefully vanished? In my estimate, what will remain is that online hearings for at least case management conferences are likely to remain. That is a very time and cost-saving feature, and I think that that is welcomed both by the parties and by the arbitration community greatly. It makes it much easier not having to travel around the world to settle these procedural matters, and to see the other party on the screen is almost as good as seeing them in a room in such a setting. So that is likely to remain. There's also something to be said for procedural questions that are being dealt with within the arbitration once it has started. The arbitral hearing maybe also be dealt with by way of virtual hearings when it doesn't come to the substance of the matter. However, the most recent survey by Queen Mary, University of London, about arbitration has shown quite interestingly that when it comes to the substantive hearing of arbitrations, it is unlikely that virtuality will take over in the future. When the participants in that survey were asked if given the free choice, whether they would opt for a purely virtual hearing, for an in-person hearing, or for a mixed arrangement, it is striking that 45% chose a purely in-person hearing. Pretty much the same number, 47%, chose a mix between an in-person hearing and online features, generally understood to opt the possibility of hearing expert witnesses, for example, or parties that may exceptionally not be able to be in the hearing room by way of video conference, but generally conducting it in person. And a mere 8% opted for a full move to virtual hearings in the future, which I believe indicates very well that an in-person hearing has something that we cannot replace by a hearing in the screen. Even the most sophisticated virtual hearing rooms are not able, apparently, to fully replenish and replace that. We, of course, have to take into account that that survey was conducted among arbitration practitioners, not among commercial parties. So it is conceivable that their interest will be different. However, I believe that also post-COVID, we will continue to see arbitration hearings that we are used to. For smaller cases, maybe there will be purely virtual proceedings when time and money involved simply does not warrant an in-person hearing involving trips across continents. But for the more substantive, substantial hearings, if you will, that is unlikely to be different from the way it is today. Which brings me to my last point, the outside boundaries of each dance floor. The freedom of the parties and of the arbitral community to develop innovation is not unlimited. Initially, under the New York Convention, the limits were quite widely drawn. What we require is a written arbitration agreement and then compliance with the reasons listed in Article 5. But within that very broad dance floor, the parties could freely design and the arbitration community could act flexibly. More recently, we have seen that states are moving closer again and in a number of ways try to restrict that freedom. I want to mention two examples of that general development. The first one, very much in the midst of discussions here in Europe, are the European Court of Justice's AIAC decisions and the subsequent decisions in Comstroy and similar cases. in which the European Court of Justice has held for investment arbitrations that they cannot be conducted if they involve two parties from the EU, because that would deprive the European Court of Justice of its ability to, in the last instance, interpret European Union law. These decisions have been fiercely criticized among the arbitration community, I believe very justifiably so. That thrust has not yet been extended to commercial arbitration. The European Court of Justice has held that reasoning does not apply to commercial arbitrations, but it is very much an open question whether that will not change in the future. And if it would, I believe that would be a significant blow to arbitration in Europe. Within the EU, one has to say, Switzerland is not directly affected, so it would be an upside for the local arbitration community here. The second example are the increasing effects of sanctions on arbitrations. That is a very novel field, and I believe it will keep us engaged for the years to come when we have to determine how sanctions there are made by the United Nations, by the European Union, unilaterally by some states, affect the conduct of arbitration. Much is unclear in this regard, but we have seen the first couple of instances where questions have been addressed from this subfield. The EU's blocking regulation that tries to keep compliance with unilateral extraterritorial sanctions, mostly from the United States, but also from China more recently, out of the European Union, is also addressed to arbitrators and forbids them to comply with those sanctions. That will influence the conduct of arbitration hearings, sometimes procedurally, but certainly as far as the matters of substance are concerned. Recently, the Paris Court of Appeal has issued a decision about the enforcement of an arbitral award made in Paris, in which it held that the UN and the EU issued sanctions form part of the international public policy. And violation of those sanctions, non-compliance with those sanctions, may make an arbitral award unenforceable. While, in contrast, merely unilateral sanctions, notably those in the United States, do not form part of the international public policy and thus, therefore, even if not taken into account by the arbitral tribunal, not prevent the arbitral awards from being enforced. Last, Russian courts have recently, before the war started, held that sanctioned Russian companies are no longer bound to their arbitration agreements, but can always turn to Russian state courts in order to settle their disputes, because supposedly they are deprived of being heard if the sanctions would prevent them from starting an arbitration. Much is unclear in this regard, but it will also mean that arbitration can no longer be the choice, or only in very well-designed cases, the choice if a Russian party is involved that is subject to a sanction, which luckily does not apply to all of them. Let me come to my conclusion. As I have tried to outline, in my estimate, also post-COVID, arbitration will remain the dispute settlement mechanism of choice for the international trade community. Not much has changed that is so fundamental that arbitration will be forgone, and the arbitration community always has to be aware that the choice by the commercial parties is what keeps arbitration alive and what keeps its place in the wider range of dispute settlements. When the commercial parties feel that arbitration is no longer right, they will no longer choose it and move on. The music, so to say, has not stopped for arbitration. The dance continues, but we will continue and have to continue to improve arbitration in bits and pieces. We will have to learn to dance more smoothly than we have done in the past, and sometimes we have to learn to dance faster in order to satisfy the wishes of the commercial arbitration community. But within that, I believe the dance is not over yet. Thank you very much for your attention.
Thank you, Professor Schroeter. We will now take a short break and resume again at 4 p.m. for our first session, Threading the Needle, Contracts and International Commercial Arbitration.